Chapter X of the plea or answer, SS 158, Answer and Burden of Proof. Usually, as we have seen, in creditors' actions to reach assets or bills in equity to annul fraudulent alienations, the debtor and the fraudulent alienees are made parties defendant. The latter are necessary parties to the end that the judgment may conclude them, and the court obtain jurisdiction over and possession of the assets in their hands, and annul the colorable transfer. It is manifest that the defendant alienee has rights in the suit different from and superior to those of the debtor. The latter is of course concluded by the judgment upon which the bill proceeds, and can withhold from his creditor nothing but exempt property. The alienee, on the other hand, may claim to be a bona fide purchaser, or may show the absence of actual fraud, and thus be allowed to hold the property as security for advances. The grantor may intend a fraud, but if the grantee is a fair, bona fide, and innocent purchaser, his title is not to be affected by the fraud of his grantor. It follows that the alienee cannot be prejudiced by the fact that judgment pro confesso passes against the debtor, or that fraud is admitted or alleged in the debtor's answer. The defense that a party is a bona fide purchaser is an affirmative defense only in cases where fraud in some previous holder of the title has been shown, and ordinarily a sworn answer responsive to a direct interrogatory or specific charge of fraud must be accepted as true until disproved. Fraud, as we have already seen, is not a thing to be presumed, but must be proved and established by evidence sufficient for that purpose, although, as already made manifest, it is sometimes practically a legal deduction from uncontroverted facts, or from evidence the weight of which is practically conclusive. Where a defendant's title is attacked on the ground of fraud, he may, under a general denial, introduce any proof showing that his title is not fraudulent. SS 159. Avoiding denial. The general rule prevails, under equity procedure, that an answer under oath, so far as it is responsive, is to be taken as true unless overcome by competent proof. When the defendant, by his answer under oath, has expressly negatived the allegations of the bill, and the testimony of only one person has affirmed what has been negatived, the court will not decree in favor of the complainant. There is then oath against oath. The complainant generally calls upon the defendant to answer on oath, and is therefore bound to admit the answer, so far as he has called for it, to be prima facie true, and as much worthy of credit as the testimony of any witness. This rule does not extend, however, to averments embodied in the answer not directly responsive to the allegations contained in the bill, since the complainant has not called for such averments. Allegations not responsive to the bill, if denied by a general replication, must be proved before becoming available to the party making them. In Green v. Tanner, the court said that the answer, being responsive to the bill, is evidence for the defendants as to facts within their own knowledge, is not denied, and by a well-established rule of equity, the answer must be taken to be true unless contradicted by two witnesses, or by one witness with probable and corroborating circumstances. In Bowden v. Johnson, it was contended by counsel that, as the bill prayed that the defendant should answer its allegations on oath, the answer was evidence in his favor, and was to be taken as true unless it was overcome by the testimony of one witness, and by corroborating circumstances equivalent to the testimony of another witness. The court found facts sufficient to satisfy the rule of equity, and cite from Greenleaf to the effect that the sufficient evidence to outweigh the force of an answer may consist of one witness, with additional and corroborative circumstances, which circumstances may sometimes be found in the answer itself, or it may consist of circumstances alone, which, in the absence of a positive witness, may be sufficient to outweigh the answer even of a defendant who answers on his own knowledge. It seems that the credibility of the defendant's answers setting forth consideration will be destroyed by proof that the vendee permitted the vendor to assert in his hearing, without contradicting him, that no indebtedness existed. SS 160. Answer as evidence for or against co-defendant. The equity practice seems to be settled that generally speaking the answer of one defendant cannot be used against another defendant. In Salmon v. Smith, the rule is recognized that the answer of one defendant to a bill in chancery which shows that the complainant is not entitled to the relief sought, inures in favor of his co-defendant as evidence. So it is said by Mr. Greenleaf that where the answer in question is unfavorable to the plaintiff, and is responsive to the bill by furnishing a disclosure of the facts required, it may be read as evidence in favor of a co-defendant, especially where the latter defends under the title of the former, where the complainants choose to rely upon admissions or confessions in an answer, The denials and admissions must, of course, be considered as a whole. A sworn answer should be taken as true unless overcome by the testimony. But the denials to make an answer evidence must be of facts stated in the bill. It may be here recalled that the testimony of a single witness, uncorroborated by circumstances, has been considered not sufficient to overcome a verified answer positively denying fraud. SS 161. Pleading to the discovery and the relief. Chancellor Walworth stated in Brown LV Curtis that, in certain cases, where the discovery asked for would tend to criminate the defendant, or subject him to a penalty or forfeiture, or entail a breach of confidence, the defendant was not bound to make a discovery to aid in establishing the facts, although the complainant might be entitled to relief. In the course of the opinion it was further said, but where the same principle upon which the demurrer to the discovery of the truth of certain charges in the complainant's bill is attempted to be sustained, is equally applicable as a defense to the relief sought by the bill. The settled rule of the court is that the defendant cannot be permitted to demur as to the discovery only, and answer as to the relief. This general rule is equally applicable to the case of a plea, and the defendant cannot plead any matters in bar of the discovery merely. SS 162. Particularity of denial and answer. Chancellor Kent, in Woods v. Morrill, in discussing the sufficiency of an answer to the allegations of a bill in equity, said, "The general rule is that to so much of the bill as is material and necessary for the defendant to answer, he must speak directly, without evasion, and not by way of negative pregnant. He must not answer the charges merely literally, but he must confess or traverse the substance of each charge positively, and with certainty, and particular precise charges must be answered particularly and precisely, and not in a general manner, even though a general answer may amount to a full denial of the charges." This rule is well illustrated in Welker v. Price, where the bill charged that the land conveyed by the debtor to his wife was all the property of which the said John F. was possessed. The answer set forth that the debtor was then in good circumstances, with means enough and more than enough to pay all his debts. This latter statement was characterized as a mere legal conclusion which a party was not permitted to draw for himself, or to express an opinion concerning, without disclosing facts to justify it, and as being a mere evasion of the real issue as to the possession of other property. It is a familiar rule that a positive denial of fraud in an answer will not prevail against admissions, in the same pleading, of facts which show that the transaction was fraudulent. Also, that in weighing the whole evidence in the case, the fact that the defendant answers only generally, denying the fraud, will operate against him whenever the bill charges him with particular acts of fraud, a charge in a bill that the deed in question was never properly delivered, and that the grantor retained possession after the conveyance, should, if untrue, be specifically denied. SS 162A. Bill of Particulars. The granting of an order for a bill of particulars in an action rests largely in the sound discretion of the court. Such orders have been granted in almost every form of action. In a special term case in New York, prosecuted to set aside an assignment as having been made in fraud of creditors, Lawrence, J., ordered the plaintiff to furnish certain preferred creditors with a bill of particulars of the times, places, acts, and things which it was intended to prove as showing the fraudulent intent. A similar application was denied in a later case upon slightly dissimilar facts. It would be destructive to creditors' proceedings in many cases to allow a debtor to exact in advance a bill of particulars of the specific acts of fraud relied upon to support the action. Fraud is generally established by developing a series of minute circumstances, earmarks, and indicia. These sometimes appear at the trial for the first time when the creditor has obtained an opportunity to explore the enemy's country by cross-examination, it may be, as the presumption of good faith in all transactions rests with the defendant, and the general character of the plaintiff's cause of action must be outlined in the pleading. It would seem to be most unjust to require, in addition, a statement of the items of the creditor's evidence in advance of the trial. Creditors are considered to be a favored class, and are entitled, with proper restrictions, to fish through the debtor's transactions in pursuit of hidden assets, and should not be fettered by any restricting orders. SS 163. Denying fraud or notice. In order to entitle a party to protection as a purchaser without notice, he must deny notice of the fraud fully and particularly, whether the defense be set up by plea or answer, and even though notice is not charged in the bill. A plea of bona fide purchaser for value and without notice must be as full under the code as under the former system of equity pleading. we may here observe that constructive fraud is not regarded as a fact, but is treated rather as a conclusion of law drawn from ascertained facts. Hence, as has been shown, where an answer denies the fraud, but nevertheless admits facts from which the existence of fraud follows, as a natural and legal if not a necessary and unavoidable conclusion, the denial will not avail to disprove it. SS 164, Admission and Avoidance. It is an established rule of evidence in equity that, where an answer filed in a cause admits a fact and insists upon a distinct fact by way of avoidance, the fact admitted is established. But the fact insisted upon must be proved, otherwise the admission stands as if the fact in avoidance had not been averred. SS 165, Avoiding Discovery. An important question is frequently presented as to whether or not a defendant can defeat a discovery by pleading that the disclosure may subject him to a criminal prosecution. Such a plea has been held not sufficient to excuse a discovery, while in many cases it is regarded as sufficient to excuse the party from answering. This same question comes up in various forms in civil procedure. And, at least in the United States, the general rule in practice is that a party may omit to verify a pleading, or decline to make a disclosure which will tend to degrade or criminate him. SS 166, Affirmative Relief. No affirmative relief can ordinarily be accorded to the defendant unless it is claimed by cross-petition, or as an affirmative defense, yet where such relief has been granted without objection in the court below, the decree will not always, for that reason, be reversed on appeal. It may be here observed that under the practice in Alabama, the fact that the debtor has other property which might be subjected to the payment of the judgment is not available to a voluntary alienee unless presented by cross-bill. The homestead may be protected by cross-bill, as elsewhere shown. The vendee, when deprived of the property, may obtain reimbursement for the amount actually advanced if no intentional wrong is shown. It is intimated in McLean v. Letchford that the court would not consider his claim to reimbursement in the absence of a cross-bill, though it is conceded that reimbursement has been made in a proper case where no cross-bill had been filed. SS 167, Waiver of Verification. The pleadings in the class of litigation under discussion are usually verified, where code practice prevails. If a verified bill of complaint is filed, all subsequent pleadings must be under oath except demurs, which, of course, only raise questions of law, though the complainant waive an answer under oath from the defendant. Yet the latter may nevertheless verify the pleading. So held in Clements v. Moore. Swain, J., said, it was her right so to answer, and the complainants could not deprive her of it. Such is the settled rule of equity practice, where there is no regulation to the contrary. It is said that the practice of waiving an answer under oath originated in the state of New York, by virtue of a provision incorporated in the statute, at the suggestion of Chancellor Walworth, and was intended to introduce a new principle into the system of equity pleading. It was designed to leave it optional with the complainant to compel a discovery in aid of the suit, or to waive the oath of the defendant if the complainant was unwilling to rely upon his honesty and chose to establish his claim by other evidence.